matter of profound public interest. Is the president immune for life for any alleged crimes committed while he was in the White House? He's also right that it would probably go to the Supreme Court either way, no matter which side prevailed in the appellate court. And the Supreme Court does have rules that permit cases like this, where there is a profound public interest in knowing the answer to the legal question and where the case is likely to end up in the court anyway, to bypass the intermediate appellate court. So from Jack Smith's perspective, it makes sense. There are two issues that he's bringing to the Supreme Court, the same two issues that President Trump's lawyers last weekend brought before the appellate court. One is, as John Glasgow just explained to us, immunity. The other is there double jeopardy here? Here's that argument. Because he was tried by the Senate for impeachable crimes alleged to have occurred in his involvement with January 6th and was acquitted by the Senate, can he be tried by a trial jury? I think the answer to that is yes, he can be tried by a trial jury. That's a novel issue, but it probably would be better if we have the answer from the Supreme Court than if we get it from an intermediate appellate court.
And Dave, do you think that this is, as Judge was saying on behalf of Jack Smith, of profound public interest rather than some political agenda?
Yeah, and I agree with everything the judge just said. And there is precedent for this. In 1974, the U.S. versus Nixon case, we saw something very similar to this, where there was a case that was expedited to the Supreme Court, and that led to Watergate prosecutions. But in the end, I do think this was going to get to the Supreme Court anyway. And because it is so important, I mean, we can all agree on that, then I think it's a right move to try to get them to move on it now. Because if they don't, then that could delay the trial from March into never.
Mm-hmm. Dave, you were shaking your head yes when the judge was talking about double jeopardy. That was an issue I wanted to bring up here. Why, expand on that. Why were you in agreement?
Yeah, double jeopardy prevents you from being tried for the same crime twice. But he wasn't tried in a court. He was put on
in Congress.
Right, in the Senate, which is not an official trial. There's not the same rules of evidence. I mean, there's no jury of your peers. This is the senators. It's so different. And that's why I think that the court will summarily reject that argument. There's other precedent of people, Alcee Hastings, for example, who go through the first process of impeachment and then get tried afterwards in a court of law. So I don't think that argument holds water.
Judge, I want to turn to another trial involving the former president. We know there are multiples. Last week, we heard that the former president would be taking the stand on behalf of his own defense. But of course, now he is not. Do you think that's a good move?
Well, you know, this is an unusual case, Katrina. He has already testified in the case as a witness for the government. And then his own lawyers more or less cross-examined him. It's not a real cross-examination because he knew what the questions were going to be and they knew what answers he was going to give in response to that. But should he take the stand as a witness in his own behalf in this civil case? In my opinion, no. Because he does have three criminal cases pending. The one we're just talking about in D.C., the one in Florida involving the Mar-a-Lago documents, and the one in Georgia alleging the alleged RICO. So if he takes the stand as a witness in a case, just as a witness, he can only be cross-examined on the basis of the testimony he gave. But if he takes the stand as a party, as a defendant in the case, then the government's lawyers can cross-examine him on anything, including issues affecting those other cases. He doesn't want that to happen, and he certainly doesn't want to give the federal prosecutors and the Georgia prosecutors a preview of how he withstands cross-examination. So in my view, a smart move for him not to testify.